One thing that stood out to me about the hypothetical is it seemed to be that one of the U.S. attorney's first moves was to subpoena the journalist for the source. That surprised me. I don't think that's our first move. In fact, if we make that move at all, it would be in the very rare case. And as you may know, before we can subpoena a journalist, either for a source or for information that they have, there is a pretty elaborate process that we need to go through internally up to the Attorney General. In most cases, we're supposed to consult first with the journalist to see if they will voluntarily share information. If that doesn't work, then both our U.S. attorney in our district and has to approve our application, and then the application goes up to what we call main justice. And then if we do serve the subpoena and it's not complied with and there's going to be a motion to compel, there's yet another process for us to get sign off on that. So none of that is taken lightly at all.
Do you have any idea how often that may happen, that Main Justice reviews these from U.S. attorneys around the country?
U.S. attorneys around the country I can't speak to. I know that it's relatively rare. I mean, I would make the distinction between getting a subpoena to a journalist for a source. I've been there 10 years. It's not something I've ever done or I've been aware of. That doesn't mean it hasn't happened. Subpoenaing a journalist for materials maybe is a little more often, but again, I think it's fairly rare. If I were tasked with defending this subpoena, I can say for sure I wouldn't want to appear in front of Judge Coate to try to defend it. I think, and Judge Coate walked through the test very eloquently. I think at every part of the three-part test, I think we would have a challenge. I think the final part of the test, that this information is not obtainable from another source, goes back to where I started, which is there are a lot of ways that we can find out about a pay-to-play scheme. Some of them are addressed later in the hypothetical: subpoenas to banks, search warrants, just agents on the ground conducting interviews. So I think that is where we're going to start. We often read things in the newspaper, and that may have influence on an investigation, but that doesn't mean that our first move is to go to the journalist and say, tell me what you've got.
I think it depends. If we're in the Second Circuit, I think Judge Coate really laid it out very well and called into question the government's ability to prevail here. I cannot see how the source of these documents is at all relevant or material to the prosecution. I also can't see how it's critical to the case. And there are many alternative sources, including go ask the wife.
Now, let's just be clear about something, though, however. We're now talking about we skipped over the fact that we're now looking for not matrimonial matters. We're now looking for some
even so, yes,
I'm
sorry, I totally understood that, but still the source of those documents is not necessary for the prosecution. And if you're trying to figure out the source, I do think the wife could still be an alternative source in addition to the banks and all of this, because it does all trace back to her, and she's a natural person to suspect as the source. So I just think that in every prong, we would win.
I think so, and I feel very confident about the path in federal court based on the analysis the way it was laid out in the hypo. But my understanding is that in state court you also have a shield law, which we don't have in federal court. So in federal court we're relying upon common law and the First Amendment. In state court we have an additional statutory protection that I think it said is protective of sources. So I'm glad to be in state court as well, although I'd like to take Judge Coate with me in her analysis. I think it was right on. But yes, I think I feel good in state court as well.